Hello, everyone. I am Jason Montgomery, a partner at Husch Blackwell. Before we begin, I would like to cover a few housekeeping items. At the bottom of your audience console, there are multiple application icons for your use during the program today. If you have any questions during the webcast, please submit via the question box. We will try to answer all questions during the webcast today, but if a fuller answer is needed or we run out of time, it will be answered later via email. Feel free to use reactions throughout today's discussion. You can react by clicking the heart icon and selecting one of the options. Toward the end of the program, be sure to complete our short survey. We use your feedback to plan future programs that are applicable to your business needs. A recording of the webcast will be emailed to you tomorrow for watching and sharing. That is all for housekeeping items. Let's get started with our program. Joining me today are Matt Mikrut, Managing Director of the Office of Committee on Infractions at the NCAA, Christina Miner, Senior Athletic Consultant at Husch Blackwell, and Taronda Randall, Senior Counsel at Husch Blackwell. And what we're going to talk about today, Taronda, next slide, is really try to get an inside look at the NCAA Committee on Infraction process from Matt. We're going to talk about the process generally, some Division I high-profile cases, current trends in infractions, meaning what are the current allegations that are being made and found by the Committee on Infractions, the status of penalties, which seems to be continually changing, maybe every year. Is that right, Matt?
We'll get into that a little bit.
What is exemplary cooperation? And risk mitigation and proactive measures. I'll turn it to Taronda.
Thanks, Jason. So the infractions process. So before we start talking more about the process and the resolution methods, Matt, your title is Managing Director for the Office of the Committees on Infractions. So exactly what or who, I guess I should say, is the committee and what is their role?
Sure. Before I jump into that, if it's okay, I'd like to go backwards a little bit. And so, yeah, that is kind of what I do currently. For the past, I came here 11 years ago, actually, with Christina Miner as postgraduate interns. And the only reason I bring that up is over the past 11 years, I've had the opportunity to serve and support the Division I, II, and III committees on infractions. And I didn't go back to look at how many cases that those have been, but rough estimate is somewhere in the neighborhood of like 220 to 230 cases. And during that time, I've only missed 4 deliberations. And I don't do that as kind of one of these, but I do that because that's a unique perspective that either us as OCOI staff or committee members have that the general public doesn't necessarily have, outside counsel doesn't necessarily have, and the enforcement staff doesn't necessarily have. So I think our attendees today, and even the general public, most have heard of the Committee on Infractions or the NCAA punishes insert school, insert coach, but most don't necessarily understand how we got to that piece. So those 225 or so deliberations that I've had the opportunity to either advise or witness, I hope to share some of that information to shed some insight and some understanding of a process most of us have heard of, but only a few of us really truly understand. So your question's an important one because it's like, okay, who decides these cases? Because I think most people see a blue disc and it says the NCAA decided case, again, insert institution. What I think is often lost is they believe it's folks like either myself or John Duncan and those that work in the enforcement staff or somebody else that may have some input into the infractions process that's ultimately deciding did violations occur and what are the penalties. But it's a peer review process. And what I mean by peer review is it is individuals who go to work or are recently retired, previously went to work every day on a college campus or at a conference office. And the importance there, as we get into some of the cases later, is these are people who understand what can occur and the potential for what can occur, how it can occur, and then the impact of a potential penalty on a college campus, on a college athletics program, on a series of coaches and staff members, and then most importantly on student athletes that either were involved in the violations or, depending on case processing time, may have had nothing to do with those. And so that's an important perspective that I don't want lost on those that are attending or watching this at a later time, is the people that are ultimately deciding these cases aren't necessarily out with pitchforks looking to issue penalties. They're those that understand and believe in the collegiate model because they live it every day. And so when they issue penalties in accordance with kind of the membership's framework, they're doing that from an educated perspective, full well knowing that they may have sometimes a negative impact on programs, campuses, and sometimes student athletes on campus.
Matt, that brings a couple questions to my mind. Now, one
Sure,
for the benefit of everyone, Division 1, 2, and 3,
yep.
This committee or office handles all three divisions, right?
That's correct. So we provide support Divisions 1, 2, and 3. And I think as I paged through the slides last night, we're going to get into some of those. Without a doubt, our busiest division is Division 1. You didn't ask this, but we average anywhere from 16 to 20 cases a year in Division 1. Divisions 2 and 3 are a little bit less. A really busy year for Division 2 or 3 would be 6, 7, 8 cases. They traditionally hover around 3 or 4.
And I think some people have the impression that because you're embedded in the national office, that there's some crossover between your office and the enforcement staff. Can you talk about what efforts you engage in to ensure that there isn't a crossover and that there is a true line of demarcation between the investigators and then the decision makers?
Sure. So our staff operates almost like a staff attorney or a clerk to a series of judges, and our judges are those, again, that I talked about a little bit earlier. The enforcement staff, again, carries out the investigations and then presents what it refers to as objective facts to the committee to ultimately make a decision. We work at a high level on broader infractions program enhancements based on, again, past cases. But once the enforcement staff's going through an investigation, the committee has no touch point on it. I or anybody on our staff have no touch point on it. Once enforcement has finished that investigation, has developed information that it believes is credible and sufficient that the committee could reasonably conclude that a violation occurred, and we can put quotes on that because that's their standard, they can issue allegations, and at that point it triggers our involvement. And the committee takes it then from basically case drop-off, case charging, through resolution of the case and issuing a decision. So there's security measures put in place. Again, there's plenty of opportunity to brainstorm and to try to solve infractions-related issues or problems, but they're never within a specific case.
And I don't know if it's intentional, but the different colors for these, green means go. So this is Division 1. And I think Division 2 has negotiated resolution as well. Is that right, Matt?
It is. So I didn't realize we had moved slides. I just see the two of you and Christina on the bottom. So I apologize for that.
Yeah.
Technology is not my area of expertise. Infractions may not be either after we're done with this conversation.
Well, the whole point is to keep you in the dark for us to grill you as to what we think is appropriate. But I guess my point being, green means go. Negotiated resolution is by far the most process types of cases currently in Division 1. Is that right?
Yep. So I believe we're talking about this chart right here. So what we have in Division 1, and actually we have in Division 2, and then Division 3 is yellow to red. So just to say that again, Division 1 and 2 are green to red. Division 3, it will be yellow to red. So it's not completely isolated Division 1. What we have here is just a quick breakdown of the different methods. So you can have negotiated resolution, summary disposition, written record, or a contested full hearing. The keys there, and I don't want this to give the signal that it gets more adversarial as we go through. That can sometimes be a byproduct. I want to reinforce, and we didn't really get into this a few minutes ago, but I want to reinforce that this is, although there are elements of the legal process, it is an administrative and cooperative process as opposed to the traditional adversarial process. What these colors represent is the level of agreement between the parties. And so green, complete agreement, think settlement. Yellow, we essentially have complete agreement except for penalties. So the committee's engagement is to look at what has been agreed to, violation level, etc., and then using past cases in the penalty framework, issue penalties. And then the next two are full-on contested cases. I can't stress enough how much cooperation is still present in those cases. And as Jason and I think are going to get into later, exemplary cooperation has now been a recent emphasis in rewarding schools that take those approaches. But it's just a level of agreement. So written record, there may be a handful of things that aren't overly substantive that would require an in-person contested hearing. And then you get to your full hearing, which essentially looks like an NCAA court hearing.
And in each of those situations, there are deliberations that you are participating in with the committee.
Correct. So just to walk through those quickly. So negotiated resolution is presented to the committee. Committee has to look at it and either give it a thumbs up or a thumbs down. It gets a thumbs up. It only gets a thumbs down. Let me phrase it this way. If the agreement is not in the best interest of the association, so a really high bar, admittedly somewhat undefined, but again, you're trusting people that live this day in and day out to understand what that is, or if the penalties are manifestly unreasonable, another pretty big hurdle. So a lot of that negotiation happens with the enforcement staff, outside counsel, and their party. And that's essentially the call. Does this meet that standard? And if so, we approve it and move it through. That's a really efficient process. Summary disposition, written record, and hearing. Again, as you move, the committee has to make more decision points. When you get to the far end, they have to find all the facts. Okay, somebody says the stoplight was red. Somebody said it was green. Committee's got to decide which one is better supported by the information. Then they have to assign based on those facts, did a violation occur? So they're interpreting to some extent the bylaws. Then they have to determine the severity of that. So level 1 or level 2 in Division 1. In Divisions 2 and 3, we're talking about a major violation. Gets a little bit more complicated as far as classifying that. But once they classify a case, then there are certain penalties that are required, and then there are other that are additional and discretionary. And so those, again, are all the kind of the decision points that the committee has to do in deliberations. Sometimes deliberations are 5 minutes, approve it. Sometimes they're a full day, particularly as cases get complex and there are more decision points that they have to work through.
One big issue for institutions is, in particular, can be a level 1 versus a level 2 case. And to the extent that you can talk about what factors go into that, the enforcement staff may have an opinion as to the severity of a case. The coaches in the institution may have an opinion. What factors does the committee look at aside from the plain language of the legislation?
So they'll look to their past cases as well. So enforcement will assert an allegation at a certain level. And Jason, as you alluded to, those are explained and articulated in bylaw 19. So you have level 1, level 2, and level 3, and then you have major, secondary, and the other divisions. And so the committee is going to look at that. They're going to look at, if we're talking benefits, right, dollar value is a factor, but it's not the factor. They're going to look at number of occurrences. They're going to look at the intent behind the activity. So was it intended to, or did it result in a competitive advantage or some other type of advantage that put schools that were adhering to compliance at a disadvantage? So if you follow that gymnastics that I just did there. And then I think I've said this at least twice already, but their past cases that they have decided, and these can go back to under the new level structure like 2012, 2013, also provide precedent, and I'm putting that low P and in air quotes, to help inform their decision-making moving forward.
Toronto, let's jump, because this is going to be the most fun I'm going to have, to the high-profile cases, because I really want to hear a little bit from Matt about how these cases are decided and what issues are discussed in those.
Sure thing. So before you two kind of dive into probably the most entertaining part of this presentation, at least from my perspective, let me give a little bit of background around the case list. So all of them are public, so I won't go into a deep level of detail, but with UNC, the hearing panel could not conclude that the university violated academic rules when it made available Department of African and Afro-American Studies paper courses, if you will, to the general student body. The violations that were found in that case related to two people who were central to the case not actually cooperating. So the former department chair, as well as the former curriculum secretary. Then we have Mizzou, another academic integrity or academic misconduct, an academic extra benefits case. With Mizzou, I think the thing that really stood out to me was the fact that Mizzou appealed, but the appeals committee upheld the penalties related to postseason ban, scholarship reduction, and recruiting restrictions. And that involved a tutor who completed coursework for 12 student athletes. Mississippi State, it was actually a negotiated resolution. It had similar penalties to Mizzou. It also involved academic misconduct. Baylor, and for Baylor, for the sake of everyone on the call, I want to read a quote from the first page of the decision. The allegations at the heart of this case centered on conduct never before presented to the COI, namely that Baylor shielded football student athletes from the institution's disciplinary process and failed to report allegations of abhorrent misconduct by football student athletes, including instances of sexual and interpersonal violence. Baylor admitted to moral and ethical failings in its handling of sexual violence on campus, but argued that those failings, however egregious, did not constitute violations of NCAA legislation. Ultimately, and with tremendous reluctance, the panel agreed. We also have South Carolina, and it was part of the series of SDNY cases a couple of years ago, and that case actually went through the summary disposition process, and it was not part of the now infamous and former IARP process. So with that being said, kind of a little bit of background for our audience. Matt and Jason, curious as to how you all feel these sorts of cases ended up in front of the committee for some of them, and some factors that went into the ultimate decisions.
Yeah, well, first I'd like to say RIP to IARP, because I think that some of our clients and some of the individuals involved in the process actually really appreciated the independent resolution process and felt as though some of those members were more open to traditional legal arguments and raising issues related to that. I guess, Matt, again, because I like to put you on the spot, what has been the reaction from the committee to that, or more from a larger perspective, the governance structure related to the IARP versus the Committee on Infractions process?
So your observation is an objective one, that the results that went through the IARP process are a bit different than the ones that went through the COI process. The decision, I was not in the room when they made the decision, in the they in that statement being the board of directors, made the decision to end the IARP. What I can tell you is the decision, and I think this is objectively fair, reinforced the peer review process that I talked about earlier, in that the membership believed that those best suited to adjudicate their infractions cases are the people that are in it day in and day out. And so I'm sure there are people that disagree with that statement and others that don't, but much like any other piece of legislation, the membership crafts how they want to regulate, what they want to limit, and in this case, who they want to adjudicate. And since 1953, largely, and I don't have my Stoner and Stoner Smith, there's a series of reports that go back a long way that have looked at the infractions process. They're in a drawer somewhere over there. I don't have them memorized, but peer review has been a core function of how the NCAA regulates and adjudicates. And the decision to end the IARP and reinforce kind of some of the tools around the peer review process were welcomed, I should say, by the COI to assist it in continuing to carry out the duty to adjudicate infractions cases.
Was that in any way related to a perception that these schools weren't adequately punished for the violations that were alleged?
I don't know if I would go that far. Go ahead.
Well, I only raised that because what it seems like is there's this constant push to imagine what an infractions process is going to look like, and most of that goes into penalties,
Sure.
evaluating the penalties, and so forth. And so I didn't know if that was part of the discussion at all, or there's been any discussion about that. I'm sure anecdotally, at least, around the office, there may have been.
Yeah, if we go on like a little history trip here, I think when the Rice Commission released its report, making a series of recommendations, some of which were adopted, some of which were not. One of those was obviously the independent accountability resolution process. There is some language in there that suggested the most egregious or serious cases go to this off-ramp, as we've colloquially called it, and that there was a ratchet up in some of the penalties that were available. You put those together, there may be an implication there, but there was no predetermined outcome that cases that went through that process were going to end up with harsher penalties. I think a lot of people started furthering that narrative, right, wrong, or indifferent, and ultimately that wasn't the outcome. You still need to have an investigation, right? You still need to have a hearing, and then you still have to have a series of educated people that are in the IRP had educated people that were experts in their arbitration and or adjudicative processes that made really important decisions. And, you know, based on the outcomes, then you had the membership react to how it wanted to adjudicate cases. So I'm not trying to intentionally like punt or dodge your question. I'm trying to answer it directly, and I hope that I did that.
Yeah, no, absolutely, Matt. I appreciate the candor. And to be fair, a couple of the cases that are on this high-profile case list were cases where there weren't findings made. And I guess one thing that would be, I think, interesting for the folks on this seminar to hear is, if the enforcement staff is reviewing information with the likelihood that there's a violation that occurred, how do we get to a situation where allegations are made such that none are found? Like, where is the disconnect internally or within the process, in your opinion?
Yeah, I think, again, that's one of the pieces of peer review. So not a criticism of the enforcement staff. They do what they are charged from the membership to develop information, look at that information, and if they believe it is sufficient and credible so that the committee could reasonably conclude that a violation occurred, the bylaws require them to make that allegation. When you have folks that, again, go to campus offices every day and they start evaluating whether or not these were violations, and by no means is it jury nullification. It's they're actually making a decision based on the information whether a violation occurred or not. That's what the role of the COI is. The two that you referenced, I believe, are North Carolina and Baylor. I would point out the uniqueness of those cases and the facts that were presented. So the first one being an academic misconduct case. The NCAA, as far as academic misconduct, the process and the bylaws require deference to the academy. What that means is the school has to adjudicate as it would for any and all students on campus, whether or not academic misconduct occurred. So every institution may have a different standard of what academic misconduct is. So that case presented based on the facts as they were presented did not establish that academic misconduct had occurred. And the committee followed the black letter law to a T, despite some criticism that came after the fact, and despite some, although less publicly, I think, visible support for the committee's decision. The other one we referenced, Baylor, I have to give Baylor's administration as we went through that case some credit, because they walked in and some of the language that Geronda read to us, they admitted that there were institutional, and my word, not theirs, but horrific and abhorrent failings that occurred on campus. The question before the committee was it an NCAA violation? And as you again went through that, the committee, in its opinion, as it went through the factual information that was developed, it did not rise to that level. And so if you keep going through that decision, which is a very, very well-written decision on a very, very difficult topic, the committee essentially said, this is a membership question, and 7 people are suited to determine whether violations occurred or not, but they are not suited under those specific facts to broaden the reach of certain bylaws to go after conduct that everybody agreed was horrible. But if that was an area that the membership wanted specifically regulated, then let's all get together through the membership process and develop legislation that specifically addresses those behaviors.
So very, interesting and good commentary on the evaluation process. And so those are a couple of fairly unique situations. So you have academic misconduct, and again, deference to the academy and how that was, positioned within the NCAA bylaws. Then you have this idea of extra benefits in the form of shielding someone from a process. So those are fairly unique. I want to understand, or maybe you can help the group understand a little more about the run of the mill. Let's call it hey, we got a recruiting violation, or and to some extent, I think there is some view that some of these are just black and white issues. It's either right or wrong. You did it or you didn't do it. And I'm trying to understand what flexibility the committee has from an interpretive standpoint or from a fact-finding standpoint to say, yeah, you did it, but this wasn't an egregious situation. Maybe the enforcement staff feels like it was, but we're reviewing the facts and we don't think that's the case. Do they have that kind of leeway to say, this isn't what we meant when we adopted this particular piece of legislation?
Yeah, I think they do it through level. So if the conduct clearly establishes a violation, i.e. the conduct was contrary to what the legislation says, the committee is going to find a violation, right? And then they can address the severity of that through level 1, level 2, or level 3. And as you might imagine, as we'll get into later, as you walk down those levels, the consequences associated with them or the penalties associated with them get more lenient, to the point where if a committee looks at conduct and says, yeah, these are violations, but they're kind of technical in nature. We don't see the advantage gain. We don't see the intent piece. They can go ahead and conclude level 3 violations occurred, divest themselves or itself, if I'm using the right conjugation, of jurisdiction and send it back to the enforcement staff for level 3 processing. And many of you that are probably on the call know Chris Strobel and his shop as far as level 3 secondary process, thousands of cases a year. Like the committee, there's stair-stepped penalties associated with certain conduct, and Chris can actually dispose of those cases pretty quickly.
Before we move on, we did it's softball season. The College World Series is upon us, and we got a softball question, I think. So I'd like to give you an easy question. I've kind of feel like I've been giving you hard questions.
You've been hitting me with some double breakers right now. So
can we just say T-ball or something that is arguably easy, because I couldn't play. I was Division I athlete. I couldn't play softball.
Fair.
We'll do slow pitch softball. How about that?
There we go.
The NCAA softball, yeah, co-ed.
By the way, just so we're clear, 7-time city champs since I've been here at the NCAA.
No doubt.
I'm retired now. That's for a younger crowd.
What is a question that came through was, what is the standard of proof that is used for infractions cases?
So I've referenced it a few times. So the enforcement staff standard is their information sufficient and credible information, paren, direct or circumstantial, and paren, that the committee could reasonably conclude that a violation occurred. The same standard, albeit just in a different order, applies for the committee. So is there in the record credible and sufficient information, direct or circumstantial, that a group of reasonable people can conclude that a violation occurred? So again, I don't ever want to see this quoted back to me in a brief, but is it more likely than not based on the information that it occurred?
So if we're looking at kind of a traditional legal, there's clear and convincing, there's preponderance, there's beyond a reasonable doubt. This is this is clear and convincing.
Yeah, it's been a while since I've been in law school, and I don't actively practice, so I'm not going to provide any any recap of how I interpret those standards. But yeah, more likely than not. I don't know if I could say it's 51-49, but it's not 49-51. I can tell you that.
Don't worry, you can and will be held responsible for anything you say on this.
Somebody's recording somewhere.
I guess before we move on and get Christina involved in this discussion, is there anything else about these high-profile cases that you wanted to point out? We pulled these because these were ones that I think at least had some interest amongst the membership. Is there anything that you think the committee would want folks that are on this call to know?
Yeah, I mean, they're difficult cases. And again, I'm not trying to ask for a sympathy plea for the volunteers that serve on the committee, but they get a lot of attention and they get a lot of hate mail. And believe it or not, we've had staff, myself included, and committee members get death threats associated with trying to do the right thing and conclude or not conclude that violations occurred or did not occur. And so I don't know what that says about, the public at large or about kind of the state of infractions cases, but you have 20 people right now, we can go up to 24, incredibly committed people that buy into integrity of college athletics and step forward to the calling to try to decide these cases, understanding some. We had one released about an hour and a half ago, maybe 30 minutes ago, that was rather straightforward. Probably not going to get a lot of negative pushback in the media associated with an NR. But the bigger the case, the higher the stakes, the bigger the fan footprint, it can get pretty ugly for committee members. And so I routinely express my appreciation to them for doing a job, and I'm putting that in air quotes because it's volunteer, that a lot of people don't step up to do, and it takes a lot of intestinal fortitude, as an old coach once told me, to do that type of work.
Yeah. Thanks for that, Matt. That was helpful.
All right. So we talked quite a bit about some, high-profile, unique cases. I want to spend a few minutes kind of talking about like current trends that we're seeing. And I don't want to leave any of this, hanging out here. So we're not going to dig into it, but at least want to address, the massive elephant in the room, which is of course NIL, the injunction enforcement staff's announcement that, NIL related investigations are paused. It's real. It's out there. It is just a pause as of, May 29th at 12:33. That's it. No more, no less. Just want to, put that out there, put that to bed for a second. And kind of move forward. But, all that being said, there are very clearly still violations being reported and alleged. Cases are being processed. Penalties are being doled out. So I want to dig into some of the other non-NIL related trends. Got questions for both Matt and Jason. But Matt, let's start with you. From your side, what are you seeing in terms of trends?
Yeah, not to play dumb and just read the slide, but if you look at the slide, 96% of the cases fall in the recruiting sphere, right? So you got 3% academics and 1% financial aid, and then everything else is recruiting. And so today, 1953, 1983, 2003, 2023, 24, you'll see a trend of recruiting violations. And I expect that a lot of our work moving forward, as the membership is having conversations about whatever the model is for Division I, and whether that has a trickle down effect on Division II and III, yet to be seen. Recruiting is going to be a piece of it. How we limit it, how we regulate it, what those restrictions are, I don't know. But if history tells us anything, whether it's intentional or not, people have tried to get around recruiting limitations or restrictions to gain competitive advantage. And I imagine we'll still see cases where people are trying to get around whatever those regulations and or bylaws happen to be in the future. So that's a lot of what we're seeing. I think also on the chart is some sports wagering activity. We can dive into that if we want. There's only been 4 cases, I think, total, one going back a few years. A difficulty there, I will say, is unlike some of the other activity that's presented to the committee, sports wagering cases are more individualized behavior that don't necessarily, unless we're talking about point shaving, impacting the integrity of a game some way, shape, or form, don't necessarily have the same or doesn't fit into kind of the level structure from an institutional standpoint. So some of the conversations that are taking place right now are, given the shared accountability for the conduct, where is it appropriate and how is it appropriate to penalize or address that conduct with involved individual behavior and institutional behavior. So I look for that to be another evolution over the next year. Probably see a lot of cases. Most of those have gone through the negotiated resolution process. But how people in institutions or entities are held accountable for it remains kind of an open discussion.
And we'll certainly get to accountability. And go ahead, Jason.
No, that's all right. Sorry to jump in, but the other elephant in the room, I think, for most people on this call, are the fact that we're kind of in a process of really instability within college athletics, and some understanding there's going to be revenue sharing directly with athletes from some institutions, in addition to this idea that NIL is involved and entities can offer whatever money to an athlete, and the NCAA right now is handcuffed and doing anything. Given those two things that are occurring at the same time, is there discussion amongst the committee about the legitimacy of what we're doing in the recruiting space, given we have to ignore this big piece? Or is it just, we're just going to handle the cases that are in front of us, and if it's tampering or if it's $5 to a prospect or whatever, we're going to evaluate that on face value, not in the context of the bigger picture?
I think it's all of the above. And again, not to be vague about it, but the cases that are presented to the committee, there's a processing lag, right? Sometimes it's as short as 6 months, and depending on how expansive the case is, sometimes that can be a year or a little bit more. And so the committee is mindful of, because they are peers, right? They're dealing with these issues, some of the ones you referenced, and just some of the, how do we monitor and how do we educate on recruiting? They're dealing with this every day on campus. And so they're mindful of the trajectory, but they're also aware of, because they lived whatever happened in their rear view. And so by the time it gets to the committee, they're deciding a case where some things may have changed, but the conduct was still impermissible at the time it occurred. So I think we have to put ourselves in that mindset. And so again, it's a little of both. The committee is mindful of where it was, how it was interpreted or impacted on campus when it occurred in 2022, but they're also not blind to the direction the membership is going. And so it's a difficult ask for the committee to adjudicate those and to penalize appropriately, but it's what they have stepped up and volunteered to do.
I'm watching the clock here, so I want to be mindful and make sure we get through at least most of these slides. But before we move on to D2, just Jason, any additional thoughts on kind of the trends on the adjudication side versus the trends that you've seen in a couple of decades of practice in terms of concerns with potential violations, kind of before you get to the, all right, now we have an infractions resolution method?
Yeah, I think the biggest issue for everyone on campus is trying to understand, where the line is, and to educate the coaches that there are still rules. And regardless of what you see in the media about NIL or revenue sharing, that the current system is still functioning as it has been drawn up by the membership. So you are going to be held accountable, to Matt's point, and kind of why I asked the question, for the rule in place at the time, regardless of what someone down the street has done or is doing or may do in the future. And to some extent, that's always been an issue that schools and individual coaches in particular compare themselves anecdotally to what they understand is going on in the industry. So I was talking to a colleague of ours who, was a general counsel at a large system, and he pointed out that his experience was there was this concept that the coaches had their own code, and the coach's code was different from what the actual rules are, and coaches felt as long as they were abiding by their own code that they were fine, and that oftentimes isn't necessarily the case.
Appreciate that. All right, so just want to again, trying to be a little more inclusive and broad, talk about Division II just a little bit. So I think, again, clearly reading some of these cases, some of the egregious behavior that seems to be a little more typical to Division I is making its way into Division II. Matt and or Jason, whoever wants to jump in first, thoughts on some of the cases at the D2 level.
I'll take a quick stab real fast. And Christina, you kind of summed it up. 5 years ago, we were largely just seeing kind of certification cases and or failure to monitor, lack of control cases from a Division II standpoint, and we were seeing financial aid cases from a Division III standpoint. And as you look at the cases that are on your screen, which I have now figured out how to look at, so I know what slide we're on, we're seeing behaviors that for a long time before that had been largely reserved to Division I. And I think I can't pinpoint exactly why that is. There might be some fluidity as far as coaches. There may be some, I'm going to call them learned traits that maybe has trickled down to other divisions, and eventually people became aware of those, reported them, and the enforcement staff investigated them. But no longer do we have kind of the run of the mill. I think you're seeing the same type of behavior across all three divisions. As I talked about in my opening remarks, you're seeing it maybe with a little bit higher case volume. I don't know about frequency. Now, there's a difference between case volume and frequency. You're seeing it with more case volume in Division I, but the Division II and the Division III cases are still pretty meaningful, and it can include some pretty bad behavior.
Jason,
yeah, my only observation is that, and in particular, we're in an area of the country where there are a lot of Division II schools that have high functioning athletics departments. We'll give a shout out to the MIAA that's based here in Kansas City. Really programs that are nationally recognized, and there's a competition level there that is significant for those communities and those institutions. And I think that competition level across the country is where you're seeing these issues arise in Division II.
All right, thanks for that. So in addition to the trends and the cases, I think it'll be useful kind of for the audience to discuss some of the upcoming changes or recent changes in the infraction space, particularly those that related to penalties, which we'll get to in a minute. So this is just kind of a precursor of what we're going to talk about. But moving just, kind of switching gears here into Division I and II and III reforms. So from go ahead.
But that wasn't a question, but I took it as one, so I apologize. So I'm going to jump in, but feel free to cut me off or mute me if I go too far. So you talked about where current reforms that were recently adopted. So January 10th, the NCAA membership in Division I adopted individual accountability reforms. We're going to go into those, but those are suspensions, show cause orders, disassociations for boosters. Heighten those a little bit. One thing that I want to make clear is I think, this is my characterization, but I believe it's supported by either meeting minutes and or the actual intent of the legislation. This was a balancing. This did not increase individual accountability while lowering institutional accountability, right? So basically, there was a directive from the board of directors, and I will not get the exact language correct, but it was making sure that those who actually carried out the conduct were penalized or held accountable at the right level. And as the membership took a look at that, they thought from an individual perspective, perhaps the penalties were a little bit light. We did not lower, they did not lower. And when I say they, the Infractions Process Committee is a subgroup of the board of directors, did not lower institutional accountability measures. Now, there's probably an open discussion about, are the penalties that are in place today, are they still meaningful and adequate given the new realities of college athletics? I anticipate those conversations to heat up over the coming months, if not the coming year, and potentially more changes to come. But that's one thing I wanted to point out from an individual accountability standpoint. Division II is now is going through that process, and the Division II Committee on Infractions has specifically been asked to look at all the new individual reforms and decide if any of them, or perhaps all of them, make sense on the Division II front.
I don't want to put you on the spot, but if you want to talk about some of the D2 reforms, just as someone who's in the room or close to those rooms where those reforms are being discussed, is there inside baseball there we can hear?
So the conversation actually hasn't happened yet. I'm in the process of scheduling the call. So what I have done with the Division II Committee is I've taken the legislative proposal from individual accountability, which I think you have on here, 2023-55, and we've provided that with the Division II Committee so that they can start looking through. We're starting to get some of those cases actually working through on a pretty speedy timeline from Division I, so I'll be able to provide that guidance and context, and obviously give some guidance as well as to the intent or rationale behind it. My three committees, or our three committees, I should say, I don't want to put ownership on that, they tend to think pretty similarly, and so I would expect some proposal as far as reform in Division II and potentially down the road in Division III, particularly around maybe show cause orders and suspensions.
I think we have a technical difficulty. Taronda, Jason, you guys frozen? Can you hear us? Apologies all. Yes, we do have a... Yep. All right. Please give me 1 second while we try to troubleshoot this one. My apologies.
Christina, in light of the clock, maybe we should just keep rolling, or would you like me to kind of just walk through some of the other, updates for our attendees?
No, I think we can. I think I also have control over it. Oh, they're back.
There we go.
Okay. All right. So before we move on to, digging into the D1 infractions reforms, Jason or Taronda, any additional questions, comments, concerns?
I thought Matt did that from the national office. He hit the button, and asking more questions. No, well, the one thing, as we're talking about these different infractions penalties, I think it would be helpful maybe to hear a little bit about what goes into evaluating aggravating and mitigating factors, and in particular, some frustration that I have heard from clients and that I have had myself is the list of aggravating factors is long, and there's some precedent on what you're going to allege in certain situations, and the list on mitigating factors is relatively short comparatively, and so that kind of lends maybe some bias to having more aggravators and mitigators, and I'm curious what the committee does to evaluate that, and if they believe that's the truth, that is the situation, or there's something else that institutions can put forward besides just pure, exemplary cooperation.
Sure. Yeah. So I'll try to be quick on that because we've had some changes in exemplary cooperation, or some proposals on what exemplary cooperation would mean. I don't want to give everybody a reading assignment, but if you go back and read the 2012-2013 Enforcement Working Group report that instituted the aggravators and mitigators, the appearance of heavy on the aggravators, low on the mitigators, Jason, as you articulated, was intentional. So we lived maybe 8 years of that. And then the Committee on Infractions took it upon itself to begin looking at, hey, we feel like maybe there's some double dinging here. So like one individual act could get you a violation, trigger a level 1 violation, and then maybe trigger 6 or 7 aggravators compared to maybe only 1 or 2 mitigators, and next thing you know, either as an individual or as an institution, you're facing a level 1 aggravated case. What the committee did is we've now rebalanced those, or balanced those. So I think the split at one point was like 13-7 It's now much closer. I think they've eliminated 2 aggravators, so we're down to 11, and increased the number of mitigators, which I think are a little bit more straightforward and objective. And that number is somewhere around 10 now. So we're close to 50-50. The other thing they did is they decoupled them. So it used to be you had to do this, comma, this, and this. And so the committee has broken those down into individual behaviors. So self-detection and self-reporting. Now self-detection, self-reporting, or timely reporting. So the committee is mindful of that. Going into it, it's more art than science, as you might imagine. It's not apples to apples. You could have a case with, 6 aggravators and 3 mitigators, and you end up in the standard range based on the weight you attribute to certain things. Past history tends to be a big one, and now we have repeat violator that was reestablished. It was part of the old world pre-2012. It's now back, as well as just how did you, in the proverbial view, how did you behave at the point you learned that there was conduct that could be a violation? Did you embrace that cooperative principle and a lot of those mitigating factors establish that? Or did, we circle up, try to control the narrative, take traditional legal tactics that made it more difficult for the committee to get to the bottom of the issue, and those could trigger a few extra aggravating factors.
Since we're here, you want to keep on rolling through and talk Prop 2355?
Yeah, I think I'm going to try to sum this all up into just a couple sentences, and we can jump into other things down the road and proactive measures as I'm kind of looking through this slide. So this is the individual accountability stuff. And basically what it did is it just broadened, it increased the ranges. So now anything that is level 2 standard or above will result in a show cause order and probably a suspension. From a suspension standpoint, it broadened to whom it would occur. They could receive it. My apologies. And it also broadened the timeline. So we were in a phase where if you got suspended for 5 games, it was just 5 days, 5 game days for 24-hour periods. Now you were suspended from 12:01 a.m. the day of the first game until 11:59 the day of the second game. So if those 5 games take place over 5 weeks, that's a 5-week suspension as opposed to a 5-day suspension. From a show cause order, again, the membership increased the ranges associated with those. So now there are, I think, longer periods of show cause orders, and what can be included in those show cause orders have also been broadened to the discretion of the committee. Disassociation for boosters, one of the things that keeps recurring in the infractions process is impermissible involvement for boosters. So as part of that disassociation, the membership expanded what restrictions could be in place. So it used to be booster couldn't basically buy season tickets or donate to the athletics program. Now it can go so far as to say boosters can't buy individual game tickets, boosters can't be present on athletics related campuses, and boosters can't make financial donations to any institutional program, not just athletics. Last but not least, so I think we're now moving into the exemplary cooperation phase. So this has been a big deal. Exemplary cooperation meets postseason ban, meets repeat violator. And there's been a lot of work that has gone into place here. One of the big questions that I'm sure Jason has teed up is how do you get exemplary cooperation and what does it get you? And so to answer those questions, because we heard it loud and clear, the IPC has now advanced legislation that arguably makes exemplary cooperation, it does make it a standalone bylaw, no longer a mitigating factor. It arguably makes it more objective, giving institutions kind of the exact things that they'll need to do or combination of things they'll need to do to get it. The bigger question, what does it get you? So before the committee could look at it and just say, yep, that was pretty good, we considered it and we gave it full weight. Now, the committee will be required to, if they determine it applies, lower a case classification by 1. So aggravated to standard or standard to mitigated. It does not change the level. So if you're already in level 1 land, it doesn't make it a level 2 land. The other thing that it does is it removes postseason ban from consideration in the first case. If we have a school that's a repeat violator and they come back in front of the Committee on Infractions in a legislated and designated period of time, they can still get exemplary cooperation, and the committee will still probably put a lot of weight on that, but the committee is not prohibited from considering a postseason ban in that second case. One of the things we've heard over and over again is postseason ban no longer exists. It's dead. That's not necessarily true. It's not true. What the postseason ban is now has been retailored to apply in some of the most egregious cases, traditionally level 1 cases, and cases that, unless you're a repeat violator, lack exemplary cooperation. So those are kind of the new reforms we've looked at. And before we jump into one more thing, if I could make one comment on the vacation of records, because this is an emerging issue that maybe hasn't been publicly talked about as much. Vacation of records is a penalty that the IPC and at some point the membership will have to consider of, is it still a relevant penalty? Is it still a meaningful penalty? And should it be made a core penalty? If you look at the committee's history in vacation of records, anytime an individual student athlete competed, the committee has, with the exception of a few unique one-offs, vacated those records. Couple things on this one. Vacation of records, at least in the committee's opinion, it continues to be a meaningful and important penalty because it does really 3 things. One, it's rooted in fair competition, which is a core tenet and something worth defending in the collegiate model. So at the end of the day, I think everybody only wants student athletes that are certified or eligible to be competing out on the field competing. So there's a purity to the competition. The second thing that it does is there's a lot of criticism that COI penalties COI penalties prescribed only go forward and impact future student athletes. Vacation of records is really the only penalty that goes backwards, addresses the conduct at the time it occurred, and specifically addresses it by vacating that result that shouldn't have happened based on an ineligible student athlete or student athletes. And then the last piece of it, and taking this to an almost illogical extreme, but it reinforces the need for robust and thorough compliance operations. So again, the illogical extreme is if there's no threat or possibility of a vacation of records, why even certify student athletes? Or in a more realistic standpoint, it's why ask the follow-up question? If I saw something suspicious that I think may have jeopardized one of my student athletes' eligibility, I'm never going to ask that follow-up question. I'm not going to monitor it. I'm not going to do a deep dive into it. But by having that as a potential penalty, it should encourage compliance operation offices, should include coaches, staff members, et cetera, that they don't want to see banners come down, trophies returned, et cetera. And so it continues to be a proper backstop, since we're using baseball and softball, a proper backstop to, again, thorough, well-functioning compliance systems.
We only have a couple minutes, so Matt, we may have to do a part 2 if you're ever willing to come back and
Let's do it. What are you doing tomorrow at noon?
I did want to ask a couple of quick follow-ups on the penalties, and you guys can see advice and proactive measures. But with respect to repeat violators in particular, is it a situation where that is part of the analysis by the committee, or is there an automatic scenario where you're up a level or a standard as a result of a repeat violator?
Great question. There's an IOP, excuse me while I use my other monitor real quick. The committee just enacted this IOP. So there are a number of circumstances that the committee is going to weigh. It's going to be, okay, what was the conduct? Is it similar in nature between the 2 cases? Same programs? Did the institution fail to address issues from case 1 to case 2? Or either case involved a failure to monitor or a lack of institutional control? So that is discretionary for the Committee on Infractions. But the legislation doesn't speak to just postseason ban. If there's a repeat violator, the legislation says that is grounds to increase or enhance any penalty. Postseason ban gets the most attention. But the committee is not going to just, anytime you show up in front of them with a second case, automatically enhance your penalties. They're a bunch of reasonable people that understand stuff can happen on campus and the impact of penalties. And so they have tried to transparently give guidance to the membership, give guidance to outside counsel on what are some circumstances where we may be more inclined to enhance penalties based on what we're seeing in case 2.
Well, this has been extremely valuable, I know, for me, hopefully for the folks on the call, and getting a little bit more understanding of what's going on behind the scenes, how the committee is separated from the enforcement staff and the inner workings of these different decision-making processes. The last thing I'll say, well, first, Matt, again, thank you for your time and participating and being willing to answer some questions that I had, and hopefully be able to provide some additional context for everyone regarding some issues that are out there. But more than anything, is there anything else you want this group to know before we let you go and I read the concluding script?
Yeah, I think the most important thing is we at the national office and at the Committee on Infractions recognize, like, sometimes stuff's just going to happen on campus. And so I alluded to this earlier, but one of the things that I think really resonates with the committee, and whether this is through outside counsel or internal conversation, is what did those in power, the executive leadership, president, chancellor, athletic director, senior administrators, what did they do at the time they learned of that? Were they cooperative? Were they on a quest to get to the truth, regardless of what the ultimate outcome may be on an infractions case? So speaking to kind of integrity and a culture of compliance, or did they start putting up walls and start, like I talked about earlier, trying to control the narrative? That's a big piece. And as we're moving into this new world of balancing carrots and sticks and rewarding institutions that do the right thing from the beginning, how the president, how the chancellor, how the athletic director, and other people in that senior circle react is a big piece. And so if I could leave any departing words in their guidance, is those first, couple hours, I think, or couple days and weeks as you're notifying the enforcement staff, deciding whether or not to get outside counsel, are really important in setting the narrative that will ultimately, maybe in like 12 months, be in front of the Committee on Infractions.
Well, thank you again, and thank you to everyone for joining us today. We hope the information was helpful to you and your school. As a reminder, a recording of the webcast will be emailed to you tomorrow for watching and sharing. Be sure to complete our short survey. We use your feedback to plan future programs that are applicable to your business needs. This concludes the webinar, and thank you to everyone.
See ya.